Mr. Martin, pursuant to Senate Bill 5164, Laws of 2021, Chapter 141, Section 1. Ms. Lee, let me defer to you first.
Thank you, Your Honor. If the court doesn't mind, I'd like to make some introductory statements within my presentation. As you may know, Your Honor, this is a historical moment for not only our office, but for Washington State as it relates to the three strikes law. Under Dan Satterberg's leadership in 2009, my office reviewed a handful of three strikes cases, and that particular team was led by our Chief of Staff, Lisa Mannion. They identified about 45 cases that we believed relief was warranted. All of these cases were three strikes cases where robbery in the second degree was a predicate offense. In 2015, after 2 years in the office, I inherited the list with the direction to support these cases in a clemency process. And to date, we've supported over 20 cases and the governor has granted clemency. As you know, in 2019, 5288 passed, removing Robbery 2 as a strike eligible offense, but it was prospective only, followed by the passage of Senate Bill 6164 in 2020, giving prosecutors the explicit authority to resentence in the interest of justice. It was my office's plan to use that new tool, 6164, to resentence the remaining three strikes, Robbery 2 cases on our strikes list, but the pandemic hit and we were asked to postpone presenting such petitions to this court. Your Honor, today, the reason why this is so important, this particular resentencing, is because now we have Senate Bill 5164, which is passed, and it requires the prosecutor to review these cases, persistent offender cases where there's a predicate R2, Robbery 2, and resentence the individual. And that's why we're here today. The three strikes law, many people have been advocating for changes in that law, particularly removing the Robbery 2. And today we have the opportunity to resentence people and provide a more fair and just sentence. And another thing that I'd like to point out, Your Honor, is that what's striking about today is that we come to you collaboratively. You have the prosecutor and defense coming together, asking for justice to be served in these cases. So we've contacted victims, Your Honor. Our practice is to telephone victims and also to follow up with a letter. We've done that and we have not heard from victims. So at this time, we could move into asking the court to agree to the standard range that we presented in our motion. So for the assault 2, it's 63 to 84 months is the standard range. For the burglary 1, it's 87 to 116. There are some deadly weapons and enhancements here, a total of 96 months. But we're asking for 84 months on counts 1, 3, 4, 6, 7, 116 months on counts 2 and 5, served concurrently for a total of 116 months consecutive to the 96 months of deadly weapon enhancements. That's almost 18 years. Today, Mr. Martin has served about 332 months, which is about 28 years. And so we're asking, as far as community custody is concerned, because community custody does apply to these offenses, we're asking for an exceptional sentence downwards. The community custody in 94 was 12 months for assault 2, 12 months for the burglary. Because the assault 2 is a Class B felony with a maximum of 10 years, the community custody cannot be ordered on those counts. We request an exceptional sentence down on community custody for the burglary 1. And the reason being is that he's almost served 28 years, which is 10 years more than the recommended sentence. As far as any LFO and restitution, the victim penalty assessment was paid and everything else was waived, so we won't be asking for any kind of LFOs or restitution in this particular case. As far as the DNA fee is concerned, Your Honor, I don't know if the court is planning to ask for that particular fee, but it appears to me, because Mr. Martin is not present and he's attending virtually, we're wondering if the court would consider some exception to the collection of the DNA fee, since DNA would probably not be collected. But of course, that's the court's decision. We understand that those fees are mandatory, but because of this kind of hybrid presentation that we have today, we're just curious how the DNA fee will be handled, and we have no objections in the event that there's a possibility that that fee could be waived. And at this time, Your Honor, that concludes the state's presentation.
Thank you. Ms. Gormley.
Your Honor, thank you. I want to echo Ms. Lee's comments about justice being served here today. And I am so honored to be representing Terry Martin in this hearing, and have been so grateful to work with Carla Lee and her office to get to this day. As she stated, Mr. Martin's case was one that the office had identified as a case where the sentence was excessive under the facts, even before the law changed. And I was working with her office and her team and with Terry and with DOC to get the records and present the arguments that a credit for time served sentence in this case would be just. And with the passage of the law, we need no longer make those arguments. But I just want to talk a little bit about why this is a wise and just sentence, and why we are so grateful and pleased that the state of Washington has taken this stance and adopted this law. Terry Martin grew up, as I laid out in my sentencing materials, in Compton, California, at the height of the violence that plagued that city in the 70s. There was violence everywhere. There were bullets fired into his home. There were bullets fired directly at him. Everywhere he turned, there were drug sales. There were bodies on the street. There was police brutality. There was the legacy of racism that has plagued this country for a long time, and that affected him deeply. As I also pointed out in my sentencing materials, Terry Martin comes from a very good family, a good, strong, loving family. But when you grow up in that kind of a poor and violent environment, people don't do well. The trauma affects people, and the modeling of violence all around you has an effect. So Terry was affected by it, and it took him a long time to understand why he reacted the way he did, why he felt the way he did. It took until a fellow inmate said, "Hey, Terry, I think you have a problem," and started talking to him about post-traumatic stress disorder, which is something we see with people who grow up in these violent neighborhoods. And as he told me, he thought that PTSD was something that veterans got. He never imagined that it was something that could be affecting him and his thinking and his behavior, but it was, and it did. And he addressed it. He continues to address it, and he goes home now, will be going home with a better understanding of himself and his history, having healed a lot of that trauma through serious work on himself. And he goes home to a strong, loving family and support system that are so anxious to welcome him back into the family and into the community. And we're just, again, so very grateful. Thank you, Your Honor.
Thank you. Good afternoon, Mr. Martin. Can you hear me?
Yes, I can.
Mr. Martin, this is your opportunity to address the court, but you are not obligated to say anything at all. But if you did want to say something, this is your chance.
Yes, I would like to. First, I would like to thank God for this opportunity, and thank you, Your Honor, and thank my attorney, thank the prosecutor. And yesterday, I can't really hear because I have a ear infection. But like my attorney said, I didn't realize I had a problem until I came to prison. So I think that I'm glad I did come to prison because I didn't know I had a problem until I got here. But over the years, I forgave a lot of people that did things to me when I was young, when I was in the 5th grade and stuff happened to me. Especially when I was young, when somebody tried to rape me. And that was emotional. And I didn't know that was a heavy burden on me. And when I got angry, I lashed out. And I didn't know that was a problem. And then by me being a guy and hold that emotion in, when I got angry, I lashed out. And then when that night of the incident, when people was breaking in my house and did what they did, and then I came up here selling drugs, and I just got mad and took it out on them. And so now, since I've been locked up, I'm not the same person that I was back then. So now I went to these meetings and went to redemption and got the help I needed, and went to mental health and got the help I needed. So now I know what to do when I get upset, you know what I'm saying? And like today, I went to, all these years, I didn't get my GED, and now they finally gave me an opportunity to get in class to get my GED, which was ironic, you know, but I learned to calm down. I learned to, now I'm taking Prozac. At that time, it was you know, you going to mental health, it was like you ashamed, you're embarrassed. Now I'm not embarrassed to admit that I have a problem, you know what I'm saying? So I'm glad that I did come to prison. I'm not ashamed to say that, but I learned over the years that I needed some help. I got the help I needed. Now I could be a better man than I was 27 years ago. So I just thank God for that. And I thank God the courts give me the opportunity to get out. And one day I want to sit in your courtroom and see how you be in your courtroom one day, you know, come back and give to the community. That's what I'm at, and work with young kids and give them a testimony to what I went through. Maybe I can help somebody else not to go through what I went through. That's what I would like to say today. So thank you.
Thank you, Mr. Martin. And I should probably start by wishing you a happy belated birthday. I believe you turned 60 a couple of days ago. Is that correct?
Yes, sir.
All right. Well, you know, hopefully this will be the best birthday present that you have ever received. It'll be tough to top this one, but let me first say that I'd like to commend the King County Prosecutor's Office under the leadership of Dan Satterberg, that, you know, the office has historically been known always to be in the forefront with respect to a progressive approach to criminal justice. And Ms. Lee, you were too young probably, but when I was in the office, the late Norm Mailing was the one who led us, and every time we saw him, he always told us to go out and do justice. And I think the office should be proud of itself for actually carrying that out and doing justice in this case, and with respect to all of the cases that the office is undertaking to review. Mr. Martin, let me just say this is an easy decision for me. I've read all of the letters of support that your attorney has submitted, and it's very clear that you are a completely different man today than when you first entered prison some 28 years ago. It's clear that you've taken every advantage and opportunity in the long time that you've been incarcerated to find ways and means to better yourself and to improve yourself and to learn from your mistakes. So I commend you on that. I think a lot of people could have just sort of thrown up their arms, be angry, and just resisted and waste their time in custody. So you have a lot to be proud of, Mr. Martin, and I agree wholeheartedly that you have an amazing support system in place waiting for you. They're desperately waiting for you to rejoin them. And one thing I want to say is, you know, I think readjustment, re-entry into the community is going to be tough for you in the sense that a lot has changed since you went into custody. And you'll find all kinds of good things, some not so good things. But there will be challenges for you from something as simple as using a phone. I see behind you a red phone that looks like it still may have dials, but you will come out and find a whole host of technology that you won't have a clue how to use. Things are very different on the outside. So what I'm saying to you is, please, please, please lean on that family that you have surrounding you. They all want to help you. They've all offered to provide assistance. They're welcoming you back. Don't try to do this alone. Lean on them and have them support you and love you and help you through this transition process. And I am 100% confident that it will be a successful transition for you. So I am going to follow the recommendation and impose, with respect to counts 1, 3, 4, 6, and 7, 84 months on each count, 116 months on counts 2 and 5, with all counts to be served concurrently for a total of 116 months. With respect to the weapons enhancements, again, for counts 1, 3, 4, 6, and 7, I will impose 12 months and 18 months each for counts 2 and 5 for a total of 96 months, bringing your total confinement period to 212 months. With respect to the community custody, the only count under which community custody could be imposed is the burglary in the first degree charge or count, since that is a life maximum in terms of maximum penalty. However, Mr. Martin, you have clearly served well beyond the recommended time based on the recalculation. I am going to find that it would not be in the interest of justice to impose any community custody. And so as soon as you are released, you have no further obligations, as far as I can tell, to the department. I am not imposing any other financial obligations. Ms. Lee, does the state wish to address the issue regarding no contact with the victims, assuming that they are still surviving?
Honor, we recommend that there should be no contact. And we have the victim names. We just weren't sure if we wanted to put their names on the record or if you wanted us to give you those names in some other fashion.
I might be able to glean them from the, let me just check, hang on 1 second. I think I can get the names from the original information, so I can handwrite those names in. So, Mr. Martin, the other conditions I'm going to impose are that you have no contact with your victims. I don't anticipate that should be a problem at all for you. Is that correct?
No problem at all.
Okay. And you are also, because of your conviction or convictions, not eligible to possess a firearm. So when you are released from custody, do not possess, use, purchase, touch, come anywhere near a firearm until or unless the court restores your right to possess one.
Yes,
Is that
sir.
understood? Okay. Mr. Martin, now, Ms. Lee, with respect to the fingerprinting, I'm not sure if the state has discussed with the DOC as to how this would be carried out.
They're outside right now.
Okay, all right. So the clerk needs to actually observe Mr. Martin affixing his fingerprints.
Yes.
right. Actually, this one right here.
Yeah, I'll hold the camera down.
Yeah. Okay, so I'm just gonna use your right hand, okay? It's just your right hand. And then actually I'm gonna have you sign it first so we don't smear the ink everywhere. So this is just for your fingerprints right here. So just sign your name. And then I think it wants you to print it right below. Still working? And there'll be another one too. Okay, and then let's see, that one's not for you. This one. So this is just going to talk about your rights to appeal. So you can read that if you need to. Oh, yeah. Okay, and the last one is just you're not authorized to possess a firearm. So they're going to do sign there. Okay, so now we'll do we're just going to do your 4 fingers, okay? So take your 4 fingers, we're just going to press them down. Sure how we look, maybe a little bit more. We're just going to go straight down and straight up. Okay. Kind of missed your pinky a little bit, but. All right, now Mary Lou's going to do the notary portion, okay?
Okay, can we borrow your pen? Mine's not working. I don't like these. They never work. And it's a brand new one I made.
See?
Thank you.
It looks like that process has been done. Council, for the record, I am signing the order to resentence pursuant to Senate Bill 5164. I've also signed the order of release of defendant from the Department of Corrections, the notice of inability to possess firearm, as well as Appendix D, which are the findings of fact and conclusions of law for the exceptional sentences. Is there anything else, Council?
No, Your Honor, there's nothing else from the state.
All right.
Not from the defense, Your Honor. Thank you.
Thank you. Mr. Martin, I sincerely wish you all the best. And hopefully will Mr. Martin be able to be released today?
It doesn't look like that, Your Honor.
Okay. Well, Mr. Martin, I'm sorry. Unfortunately, you might have to wait another day, but I hope you sleep well tonight.
Yes, I was sleeping very good. Thank you, sir.
All right. Thank you, Mr. Martin. And again, I wish you all the best.
Thank you.
Thank
Thank you,
you.
prosecutor.
Thank you. You're welcome.
All right, that will conclude this matter.